Boris.
Thank you, Your Honor. Appreciate the opportunity to be here. I represent Richard Castle, and this case arises under a motion to dismiss. I was almost tempted to change it to a motion for summary judgment based on the last argument for Judge King. But in any event, the facts here are relatively straightforward. The Castle mortgage had a monthly payment of $396.81 per month. The force-placed insurance policy that was obtained by Capital One had a monthly cost of $200, over $200 a month, 50% of the monthly mortgage payment. Castle's complained because the insurance policy that was obtained had several features. First, it was backdating the policy. As of April 6th, they said, we're going to issue a policy today on April 6th. It's going to go back to February 6th. The second issue was it was overlapping. The overlapping occurred because while it's true the Castles let their policy expire, they had obtained a new one that became effective on March 30th.
Now, what, overlap for 8 days?
7 days, yes.
7 days. That's what, and you say backdated?
Yes, the backdating
It was
is
backdated to the time that the first her policy lapsed.
correct, Your Honor.
And it's an occurrence policy or a claims-made policy?
Well, that's one of the issues we don't know. The only thing that was presented to the court.
Well, if it's an occurrence policy, it's got to be cover the period.
Well, the reason the backdating becomes important is, and what we don't know.
Like if it's an occurrence policy, they got to get it covered to cover the period where the lapse was.
Well, not necessarily, Your Honor, because the issue becomes whether
Policies like this are occurrence policies. They're not claims-made policies.
Well, we never got the policy, Your Honor. The only thing that was ever submitted to the court was a binder that specifically said it was subject to the terms of the policy that was never presented to the court. I mean, ordinarily, if you have a document within your possession and it's not presented as evidence.
Well, you have your own. Did you have your client's policy?
No, this was a policy issued by Capital One.
Yeah, but your client had a policy.
Yes.
And it was an occurrence policy, right? You know that?
Yes.
All right. Then at February 6th, there was no more insurance. So
yes.
They had a right to buy insurance to cover the lapse. And they covered 50-some days, 52 days of the lapse, or whatever it was. You say they backdated, but that's misleading because they had to cover, they had to get an occurrence policy, which means if there was a fire on February the 7th, there had been no coverage to protect anybody.
Well, Your Honor, but the issue is that they bought, as far as we know.
And your client and themselves.
As far as we know, Your Honor, when they issued the policy on April 6th, we know as a factual matter that there were no fires. There was nothing.
Well, it wasn't a fire, but you could have a claim come up later. I mean, somebody may have fallen through the floor or something and file a suit a year later.
Well, Your Honor, actually, according to their binder, and again, we don't have the full policy.
Occurrence policy, it's a matter of when was the occurrence? Well, if it's on February the 10th, even if the suit's brought a couple years later, you need to have insurance in effect at that time.
Your Honor, two things. One is actually the policy, according to the binder, did not cover personal injury. So in your example, this policy would not cover it.
That's a bad example.
The second issue is whether or not.
But they need to cover the lapse period.
Well, here, since we knew the facts that there were no calamities, unless there was an unknown calamity that occurred, and then that would lead to the issue as to whether or not the policy would cover something that was unknown at the time it was issued. There's Maryland case law to the effect that, there's a case where the person went in and bought a nationwide policy the day after a car accident. The Maryland court said that they would enforce it because the facts relating to the accident that occurred the day before were known to the insurance company. So if their basis for covering back things is to cover things that may be unknown, that was the argument that they made, there would be no notice to the insurance company, so we'd have an entire fight over whether the policy would even cover it. But there is also the overlapping, and I apologize if by saying backdated meant I wasn't saying that they created, I'm just saying it went back to a period of time prior to its issuance. Okay? So on April 6th, they created a policy. At that time, there was no damage to the property. There's been no claims made on that policy, and it did overlap. Then the other issue that was involved was whether or not the amount of coverage that was obtained was appropriate. The amount of coverage that they obtained was the original loan amount was $75,000. It was taken out in 2009. At that point in time, it would be no greater than $75,000. There would be some principal reductions over the 3 years of payments.
Where is all this going? You've got a complaint which it seems to me to have a number of fraud-based counts, and the district court is saying, no, I don't see any affirmative representations, and what the insurance company did here was consistent with what the representations were made, with the representations that were made in the deed of trust. And then, of course, there are the questions about reliance, but it's a fraud-based complaint. And when you read through the complaint, you see these counts are basically fraud-based, and you point out that this is here on a motion to dismiss, which is true enough, but there's also a heightened pleading standard that you have to deal with on the elements of fraud, both with respect to the affirmative misstatement, misleading misstatements, and also with respect to reliance. I think that's at least a part of what you've got to overcome. And you've got to overcome it specifically because one of the points the district court makes in his opinion is that the complaint was drafted at a pretty general level about the evils of force-placed insurance. And that may be true, but how did these people engage in fraud? I guess at its simplest level, that's what I'm kind of interested in hearing from you.
All right. Your Honor, and as a preliminary, it was not a fraud complaint. It was a complaint under two Maryland statutory acts, the Maryland Consumer Protection Act and the Maryland Mortgage Fraud Prevention Act. They were not just simply codifications of a fraud claim. They specifically, and the reason I point that out is because the judge analyzed it strictly as a fraud claim and applied the elements of a common law fraud. And we did supplement the brief with a recent Supreme Court opinion that came out on the 13th. In that particular case, Janowski versus Countrywide.
Well, that case dealt with rescission. It was a question of remedies under a federal statute.
It was a question of remedies, but the reason we cited it, Your Honor, was for the reason that in that decision, they argued that they had a common law analog to the rescission under the statutory Truth in Lending Act. And the Supreme Court said that there was no tool of statutory construction that requires you to find an analog to common law when interpreting statutes. And in these particular cases, Your Honor, the Maryland Consumer Protection Act does not have a reliance element built in. What it does have is an injury in fact.
You say this is not a fraud-based complaint, but the statute is called a Fraud Protection Act.
Well, I was discussing the Consumer Protection Act first, but the Maryland Mortgage Fraud Prevention Act, yes, it does talk about fraud. And both of these statutes create an affirmative duty to disclose information that might be important. And the information that we think was important here that wasn't disclosed and which, by the way, the district court found there was a genuine material issue as to fact as to whether or not the failure to disclose the back arrangement between Capital One and these insurance companies was something that a consumer would want to know or a mortgage holder would want to know. So there was a genuine issue.
But the Consumer Protection Act still has as an element, you have to allege a misrepresentation.
Well, you can either misrepresentation or omission.
False or misleading oral or written statement, or failure to state a material fact, if the failure deceives or intends to deceive. Now, that would seem to convey a view of reliance. And when you look at the deed of trust, I mean, force-placed insurance, I don't have any brief for that. But when you look at the deed of trust, and the deed of trust says if you let your policy lapse, you had a hazard policy, and it lapsed, we're going to purchase insurance at our own expense, and you're going to be on the hook. And then they go, it says, borrower acknowledges that the cost of insurance coverage so obtained might significantly exceed the cost of insurance that borrower could have obtained. Now, if they're going about this business in a misleading way, why would they put you on notice that if you let your policy lapse, you're going to be on the hook for a policy which may have a good bit higher premium?
Right.
Is that?
In this case, it was 6 times higher, and we're not disputing that.
So that's a true representation. I mean, that's absolutely true right there.
That is true, Your Honor. But if someone's saying they're buying insurance, I don't think it's unreasonable to assume that they're buying it at market rate as opposed to have a preset arrangement to buy insurance that's going to have attributes that other insurance wouldn't have, where the company has created a profit center. You know, in a car dealer situation, you know, the standard disclosure now is where they tell the person that, you know, the interest rate that you're paying we may recover part of that, us, the dealer. There's nothing here that tells someone that, look, we've created a profit center here. That says that we're going to buy insurance, which leads someone reasonably to believe that it's going to be a fair and reasonable approach to buying that insurance, not that we're going to buy insurance from captive companies because we get money back from there. Is that fair? If the answer is that you all think that would be fair, I mean, there's no reason that this is a profit center.
Did you alter your behavior based on any of this?
The altered behavior, and going back to your reliance, I think the issue of reliance here is where you're paying for something that you consider to be excessive because of deals that you don't know about. That if you paid, I'm sorry, Your Honor.
Oh, no, I was just going to reiterate Judge Wilkinson's question, which I took to be, did you alter your behavior because presumably, or I don't know if this is where it was going, but presumably if you let the occurrence policy lapse because of inability to pay, it's difficult to imagine that you would have been able to afford a different occurrence policy regardless of the amount of premium.
May I answer?
Please, Judge Wilkinson.
I'm sorry.
Oh, answer Judge Duncan's
All right.
question. It's the same question.
Yes, and here's the issue here is, Your Honor, okay, so I didn't cover myself with insurance. Does that give them the right to create a profit center where, in essence, I'm paying for something that's unnecessary?
The question went to reliance.
Right. The reliance is I paid, and that's what the facts were here. I paid on this expensive policy that I shouldn't have had to pay on, and if I had, the judge dismissed it saying, well, it doesn't say that you wouldn't have let it lapse. Those were his or that you wouldn't have entered into the agreement. But I think one of the reliance here, and it goes to injury in fact under the Consumer Protection Act,
The
is
premium be
were you
higher
hurt by it?
because- Would the premium be substantially higher because it was force-placed insurance and because the insured had let the policy lapse? Would it be, an insurer, a force-placed insurer, regard that as a higher risk than somebody who was paying their own way with insurance?
Yes, Your Honor, but in this particular case, what we alleged was, in addition to just the general increase in the amount, that what was happening here was how this system was set up was they were going ahead and hiring this outside insurance company, and the overhead expense for that outside insurance company was being bundled into the premiums. So we were, in essence, paying for the insurance company to do this search.
Now, you're not,
When-
are you alleging, you're not alleging any kickback to Capital One from National Assurance, are you?
We are. We did. We alleged that there's a kickback procedure because they're being paid for something when they don't do any work for it.
No, but did Capital One, in selecting National Assurance as the force-placed insurer, receive any kind of kickback from National Assurance?
We allege that that's exactly what happened, that they're getting payments on this insurance that they're selling to the homeowner at the homeowner's expense, and that as a result,
But
as part...
What did Capital One have? Did Capital One, you're saying Capital One received a kickback?
Capital One received a kickback in two ways. We don't know all the details of exactly, except one way we can tell is one of the servicer's obligations under the mortgage, under their servicing obligations, was to retain or review these files to see if there was insurance in place. By entering into this agreement with Assurant took over that obligation. Assurant was doing their
Which
work
obligation?
for them.
To review the files?
Right, to determine whether insurance. Assurance takes over that obligation. And because Assurant is taking over that obligation, they're turning around and increasing the premium to cover their costs. So Capital One is being
Why
paid
is that a kickback?
because they're getting...
You mean because Capital One doesn't have to take over the policy, or?
They're not having to provide services that they're obligated to pay. In our complaint, for instance, one of Fannie Mae's problems with this whole situation is that they're being double billed. That they're
You
paying
mean
Capital One to be...
Capital One receives a kickback in the sense that they don't have to incur service costs.
They don't have to provide that service that they're obligated to
That isn't-
provide.
That's not any kind of classic kickback. That's a situation of where the insurer simply charges a higher premium in part to to undertake those service costs on its own.
Your Honor, if you hire me to go deliver a package for $15 and I get someone to come in and do it for me, I don't have to do that work. I've benefited from that. It's not a cash payment kickback, but it's definitely a benefit to me as a result of giving that other person the work.
But businesses negotiate for benefits all the time.
That's true, Your Honor, but the issue here is...
That's what being in business is about.
I'm not disagreeing. My point here, Your Honor, is that you have Capital One creating a profit center out of providing insurance. And if I breach a contract with you, are you allowed to charge me a penalty for the breach, or are you only entitled to the benefit of what you bargained for? By allowing them to make this a profit center where I'm paying more for insurance, or even insurance that maybe is unnecessary, they are getting they are imposing a penalty on me under this contract. I am paying extra for something over and beyond what I'm obligated to pay under the
Which is
contract.
wrapped into that extra premium, is that what you're saying?
Yes, Your
But they
Honor.
disclose to you that it's going to cost more.
They don't disclose, but they don't disclose why. They don't disclose we have a deal in place where we're going to charge you these extra things. Where
Well, they
we're
have to have somebody kind of on call, or at least so things lapse all the time. They got to get on the phone and tell somebody we got to have a lapse policy on that house over in Hagerstown.
There's no question. The question is whether, and here's the thing, but that's the point. They had someone set up searching the files. The company is doing the searching here. They're taking over their duties, providing them a service.
That way they prevent losses if there's a lapse and there is a fire. They need to keep on top of it.
Yes, but they're already being paid to do that by Fannie Mae.
So it seems to me that you allege a practice that in general terms is open to abuse. The two Maryland statutes that you cite, the Mortgage Fraud Protection Act and the Consumer Protection Act, are written in somewhat general terms. Is this, if the practice has some undesirable aspects to it, I'm wondering if the best way to get at it isn't through a Maryland statute specifically targeted at force-placed insurance and the abuses that can occur in the practice, rather than, I know your response will be to, well, the legislature's already done that with these two statutes, but they're very general in nature, and I'm just, are there bills before the Maryland legislature addressing this topic of force-placed insurance? Because I don't really have a handle on, how high the premiums are, how much higher the premiums are, how much is too much, what is the increased risk, and the like. And it strikes me as something that might be the subject of a legislative hearing.
There's nothing pending that I know of, but I would, as you predicted, I would say the Maryland mortgage fraud was really directed towards mortgage relationships, including the servicing. So Maryland had the General Consumer Protection Act, but they did create the Maryland Mortgage Fraud Prevention Act, which addresses servicing issues. And we were here on a motion to dismiss, and the question is, we never saw the policy, so the assumptions as to what type of policy or anything else.
You didn't have any discovery at all.
We didn't get there, but we do have information, and we did produce information in the complaint setting forth that there's various studies going on, there's various information, that in fact this is the
You're
same.
getting discovery in some other cases around the country, though.
Well, it's a very hot issue. I don't.
New York,
yeah.
the Insurance Commission did some studies.
Right, and that's what we alleged, and it's the same company, and there's public reports from Assurant that talks in terms.
Same insurer or the same force-placed insurer?
Same force-placed insurer involved here. So I apologize.
Okay.
Thank
you, sir. All right. Mr. Scott, let's hear from you.
Thank you, Your Honor. May it please the Court, I'm Robert Scott from Ballard Spar in Baltimore on behalf of the defendant, in this case, Capital One. As Your Honors correctly pointed out during Mr. Borson's argument, the plaintiff in this case decided to plead this as a fraud case. It's a claim under the Maryland Mortgage Fraud Protection Act and a claim under the Maryland Consumer Protection Act for deceptive trade practices. Both of those claims require allegations of reliance. I took some action to my detriment based on
misrepresentation.
Of course, either an affirmative misrepresentation or an omission of some information that you have a duty to disclose. The district court found, I think correctly, that there is no allegation anywhere in the complaint of an affirmative misrepresentation.
This is really an omission case.
I'm sorry?
It's an omission case here.
Correct. So what we're left with is omission. And you have to allege that there was an omission of information that the defendant had a duty to disclose and that you relied on that omission. In other words, I would have done something differently if they had told me this. If they had told me what their business practices were with respect to how they purchased lender-placed insurance, I would have done something differently. Okay, what? What would you have done differently? There's nothing in the complaint alleging what the plaintiff would have done differently. She doesn't allege she would have got the loan from another lender. She doesn't allege she would not have allowed her insurance policy to lapse. In fact, she admits the reason it lapsed is because she couldn't afford the premium. So that would have happened regardless of what she knew or didn't know about these alleged practices with
So
respect
she could have amended and fixed this.
I'm sorry?
She could have amended the complaint and fixed this.
She could have either pled a viable cause of action initially, Your Honor, or she could have attempted to amend under
She
rule.
made a motion to amend, didn't she?
No, she didn't, Your Honor. And in fact, she didn't need to
I thought at
because
the end of one of the responses, she said, if the judge rules against us, we need to amend.
she did put that at the end of her response to our motion to dismiss. However, under Rule 15, she had the right to amend up to 21 days after we filed our motion to dismiss without leave of court. So she could have amended without leave of court after we moved to dismiss.
So she wasn't authorized to amend, you're saying after that?
Well, I'm saying she could have amended, she didn't, and then after the time ran, she never filed a motion to amend.
No right to amend.
Right. I mean, she had the right to amend, she just didn't do it.
Okay.
And until after.
This whole practice of forced place insurance, it does strike me that it's open to abuse. And number one, the rate, if counsel's correct, that it's 6 times higher than her original policy. That's quite a jump up. Number one, I mean, your deed of trust said that it may be significantly higher than the insurance the borrower could have taken out on their own, but you do put the word significantly in there, but 6 times?
Well, Your Honor.
Did the premium jump 6-fold?
3 points on that. Number one, if she's alleging that the premium is not authorized by the deed of trust because of the language of the deed of trust, that's a breach of contract action, which she hasn't brought.
It is 6 times more, though, right? The premium? She was paying $400 and some, and it went to $2,400
I believe that's what they allege.
annually.
Correct. Here's the other
So those are the facts of the case. And you got the coverage for extra period of time, 7 days, he says. Did anybody give her money back for those 7 days?
She alleges that she did not, but that we dispute that, but I mean, we're on a motion to dismiss, so I'm not going to get into a factual dispute. But the other point here is who pays the premium? I mean, we hear a lot of talk about these premiums being exorbitant. The servicer pays the premium and then seeks reimbursement from the borrower. These premiums are paid by the lender.
But for the full amount, and it becomes a part of the, I mean, it's backed up by the security, the property.
Correct. That's true. And to the extent there is adequate security there and the lender is able to recover that, ultimately, they are entitled to recover it. But in this case, the borrower defaulted, didn't make the payments. So that premium was paid by Capital One. It wasn't paid by her. She may have made a few payments after that where she paid some money into escrow towards it.
What increased risk justifies a 6 times increase in the premium? I mean, that's really pretty steep. You're almost guaranteeing a foreclosure in that kind of situation. It's almost like I mean, I'm not saying this is true, but a bank that wanted to force someone into a foreclosure could have a relationship with one of these force-placed insurers, and the premium could simply drive the homeowner into foreclosure.
Well, Your Honor, I know of no reason why a lender would want to force a performing loan into foreclosure. I mean, it's not in the lender's interest to do that. These premiums are set by the insurer. And that's, the insurer's explanation, and we've put a footnote in our brief about this, is that they're underwriting these policies blind, okay? There's no ability, when I go out and buy my homeowner's insurance, if I buy a new house, insurance company has the opportunity to contact me, ask me questions about the house. They have an opportunity to do underwriting. In this situation, there is no underwriting. They're putting a policy, in many instances, after time has already passed. They're insuring something, some period of time that's already passed. And there may be, if somebody's not paying their mortgage and they're not paying their insurance, there's a higher risk that there's going to be a loss. They're not going to be keeping the property up. They're not going to be shoveling their sidewalk. They're not going to be maybe putting new batteries in their smoke detector. They're maybe not going to be maintaining their
Those are
furnace.
riskier
Yes,
situations.
absolutely.
They say you're also inflating the coverage amount.
Well, yeah, she complains about the coverage amount. And she says, first of all, the deed of trust says you can only cover yourself, lender. You can't cover me. That's completely wrong. The deed of trust authorizes.
What'd you
the
do
lender.
here? You covered, what, the fair market value?
We bought a policy in the amount of her last policy.
Right, and I believe you also asked, if I remember this correctly, for notification if there was some information that would verify that the amount should be different.
Right, we sent her a letter with the policy, and we told her the amount of coverage. This is at Joint Appendix
330.
330 and 31. We sent her a copy of the binder, and we told her the amount of this policy is based on your lapsed policy. If you have information that this coverage is not appropriate, please contact us.
So you made the
with that
coverage
information.
exactly what she had already had?
Correct.
What was it, 236,000?
About, yes.
And 75,000 or a little less was your mortgage.
Right.
So
And she's named as an
if there
addition-
had been a claim, you'd have been entitled to your 75,000, and then she'd have gotten hers.
Correct, because she was named as an additional named
You were
insured.
protecting her, it'd be your protection.
Absolutely. She would have been entitled to the rest of that insurance.
So you don't dispute that your insurable interest is the amount of the debt?
The maximum amount that we would be able to recover under that policy is the amount of the debt. We don't dispute that. And she would
So
be
you're
entitled.
protecting her equity with,
Correct.
with the
Yes,
236.
correct. Yes. And the deed of trust explicitly says the coverage we buy may or may not protect your equity in the property and your possession. So this isn't, this, again, let's go back to, this is a fraud case. She's claiming she was defrauded. We told her in the deed of trust that we were going to buy insurance. We told her it was going to be more expensive. We told her it might or might not cover her equity. And that's exactly what we did. And then when we did it, we sent her a letter and said, here's the insurance, here's how we determined the amount of coverage.
Maryland statutes are fraud-based
Yes, they are, absolutely. And that's what
because
the
of
court...
their language alleged misrepresentation.
Well, the Maryland Court of Appeals has made crystal clear, and we've cited the cases on page 21 of our brief, that reliance is required under the Maryland Consumer Protection Act. For a claim under the Maryland CPA, a deceptive trade practices claim, you have to allege reliance. That's beyond dispute. They seem to be claiming now that under the Maryland Mortgage Fraud Protection Act, that's a newer statute, and the Maryland Court of Appeals has not issued any decisions under that. They seem to be arguing, well, under that statute, we really don't have to show reliance because it's a broad remedial statute and the reliance is not an element. Well, number one, there's no case that supports their argument. There is a case which they cite in their brief from the District Court of Maryland, the PennyMac case, which we cited, which says fraud is an element, reliance is an element of a claim under the Maryland Mortgage Fraud Protection Act. So the courts that have weighed in on that have said it is a required element. And it only makes sense because if you don't have reliance, if somebody makes a misstatement and it's floating out there in the air and you haven't taken any action based on it, it hasn't altered your behavior, you haven't done anything that caused you a detriment, then how do you have a claim? Without reliance, there is no claim because there's no causation, there's no harm.
No harm, no foul.
Correct.
Very-
Even assuming that we obviously dispute that there's any omission here or that we had any duty to disclose this or that there's any misrepresentation. But we're on a motion to dismiss. So even assuming that that's true, there's no reliance. I'll also point out that this argument about reliance was not made in the district court. There was no argument made in opposition to our motion to dismiss that they did not need to allege reliance. To the contrary, they argued that they had alleged reliance. And if you look at their opposition to our motion to dismiss, which is in the joint appendix, you will see that that's exactly right, that they do not argue that reliance was not a required element. So this is a new argument being raised for the first time on appeal. We don't think it should be considered. We also think it's wrong. I mean, it's only common sense.
Does Capital One invariably go to national assurance for forced place insurance, or do you deal with a variety of insurers?
At the time that this took place, I believe there were multiple companies being used depending on where the loan was originated.
Well, multiple companies that were under one umbrella company, or are they really multiple independent?
No, they were competitors. I mean, it depended on where the loan came from. Capital One acquired different banks, and it would depend on where the mortgage came from, and that determines the insurer.
Was the policy also the forced place insurance would be, coverage would equal what the lapsed policy had been, like here with the 236?
Yeah, there was a policy in place.
That was the amount of coverage you'd get.
Yes.
You go out and get 236 to replace it.
You got whatever they had in place at the time that the insurance lapsed. In other words,
when
their
you
last
monitored
policy.
all this stuff, did you have a system in place where if you covered too much of a period, like here the 7 days, that they get a credit?
Yes.
That's 7 days, because that's an overcharge, right?
Yeah, they get a credit. They are entitled to, and they receive a credit for all the period of time that they have their own
That'd be
policy.
unearned premium.
Correct.
So there was a safeguard for that.
Yes, absolutely. And I think the correspondence even says, if the letter, which is JA 329 through 331, says, if you get your own policy, there's going to be a refund. And she apparently claims now that she didn't get it. Again, if that.
But under the procedure, she should be reimbursed for the 7 days of coverage we're talking about here. I'm
Yes.
using that. That's what we got specifically in this
Right.
case.
Under the procedures, she would be entitled to that. She claims she didn't get it. And again, that's not fraud. That's a breach of contract. If you're arguing, look, I was entitled to a refund for 7 days, that's a
Well, I think
breach
I'm just
of
kind of
contract.
Judge Wilkinson and I too, maybe we're exploring how this kind of insurance works. And I thought they alleged that you were covering excessive periods and putting too much coverage on.
Correct.
I know, and definitely then they said in there you're overcharging because you're getting 6 times, you got a premium at 6 times.
You understand the potential for abuse here, because when you have a lender dealing with an insurer, and you give it, the insurer's business model lies on very high premiums for forced place insurance, and in return for the lender selecting a particular forced place insurer, the insurer imposes a prohibitively high premium and kicks back part of it to the lender. I'm not saying that happened here, but the conditions are not impossible conditions for that kind of arrangement to get started.
I don't disagree with that at all, Your Honor. In fact, if you look at their complaint, the first, 15 pages talks about conduct of the industry and Assurant and other companies, and doesn't talk about Capital One. The fact of the matter is Capital One was not getting kickbacks. That allegation is completely false. We're here on a motion to dismiss. I'm not going to argue about the truth of their allegations, but the bottom line is that it's not true. There may have been other people in the industry, other companies doing that, and that's why they have all this information in their complaint about other companies. That's guilt by association. They don't have a good faith basis to allege that we were getting kickbacks, because we weren't.
Well, I'm glad you didn't comment on the truth of the allegations.
The only other point I want to make briefly is about the backdating. They complain about and Judge King, I think you had it exactly right, that the lender's obviously entitled to buy a policy that's going to cover a period for when there was no coverage. And in fact, recently, the CFPB, the Consumer Financial Protection Bureau, enacted regulations about force-placed insurance to address some of these complaints about abuses. And they enacted a rule at 12 CFR section 1024.37E3, which explicitly permits a mortgage servicer to buy insurance for periods of time that have passed, so that they can protect, as long as they're providing for continuous coverage, which is what we did here, that's permitted under the regulations. And this,
So the regulations authorize the backdating.
yeah,
That's your position.
yes, and although we don't, the term backdating is
Backdating
I
has
think
a bad connotation.
yes.
You have to cover you cover the lapse period.
Continuous coverage, I think, is the preferred term. I mean, that's what we're doing. We're making sure that there's continuous coverage from the day her insurance lapsed until she had her policy in place. We buy a policy. And his argument is, well, that there's no fire. There wasn't a fire during that period of time, but there can be all kinds of unknown losses. And it doesn't have to be somebody slipping on the sidewalk, personal injury. You could have water leaking in your house and not notice it. There are all kinds of things that could happen during that period of time, and the lender is entitled to purchase insurance. And courts have recognized that.
How is the buyer ever going to meet the stepped-up premium when the buyer couldn't even meet, when the borrower couldn't even meet the far less premium? I mean, are we in a situation where the borrower is simply relying upon forbearance on the part of the lender? Because you know that if they couldn't meet the much reduced premium, they're not going to be able to reach the larger premium. So we really are in a forbearance situation, aren't we?
Well, what it means is...
You have a right to foreclose if the security is not insured.
Correct. But if in fact the lender has to, if in fact the borrower allows the coverage to lapse because they cannot afford it, who ends up buying, who pays for the insurance? The lender pays for the insurance. And then if there's enough security down the road, maybe they can recover that. But in most instances, the lender ends up paying for this, pays the premium, and forecloses and never recovers the amount of the debt, let alone the amount of the insurance. So there's no incentive on part of the lender to pay a higher premium. That's part of the fallacy of this. The lender, in the vast majority of the cases, is the entity that's paying for this. They're the ones that eat this cost. It's very few borrowers who actually end up paying these premiums. Because in most instances, they default on the loan, they don't make the mortgage payment, therefore the escrow doesn't have any money to pay the insurance lapses, and the lender has to go out, the servicer has to go out and buy insurance. So there isn't any incentive for the insurer to pay that premium.
Well, you get your insurance, you get those premiums. If you got a piece of property that may be worth 3 times what the loan was. That's pretty good.
It's pretty unusual, too, in today's market.
This particular case looks pretty good for you.
Well, ultimately, if that were to happen, yes, Your Honor. But again, the upfront payment comes from Capital One, and there's no incentive for us to want to pay more than we need to for insurance. Thank you, Your Honor.
Thank you. Yes, sir, you have some rebuttal. Please step forward.
Part of the problem with the argument you just heard is repeated references. The lender doesn't want to do this. The lender doesn't want to foreclose. Who you were hearing from was not the lender. You're hearing from the servicer. The servicer does not own this loan. They're not out the money. He's right. It is the lender, but they're not the lender. They're the servicer. So all of his arguments, how...
The lender at this point?
Fannie Mae. So all of these arguments that somehow we wouldn't do it because it would hurt our investment simply do not apply to them. And I had, one of the allegations in the complaint was that Fannie Mae has complained about this because they're paying twice. That if they ultimately end up paying this premium, they paid the servicer a fee And as part of those services, they were supposed to look at the whether the property was insured. And instead, there's a third party coming in who's charging excessive premiums to cover that cost. So they are not the lender. So all of those arguments, but even if we go beyond that, you know, how are we ever supposed to know? I mean, they tell you all these nice sort of, you know, what I would almost call cliches, that of course it's going to cost us more, and of course the premium's higher because we don't have the right to inspection, we don't get to underwrite like we normally do. How do we know any of that's correct? Is there really, I mean, we allege in the complaint that some of the people say, well, if there's no underwriting, actually it should reduce the cost.
Well,
It
it comes back down, I mean, we can talk about the practices of the mortgage industry and the pluses and minuses of those, but it comes back down to whether there are affirmative misrepresentations or material omissions, and whether there was reliance in some way upon those, and whether you've adequately pled those under the Rule 9 pleading standards. And that was what the district court put its finger on. And I think the discussion has been very interesting, but I'm not, you know, it's at times ranged a little bit far afield.
I understand, and let me go back to the reliance issue. Because one of the things he did say is, you know, what's it matter to these people? What's the detriment? You know, that's the purpose of these statutes, is to prevent detriment. Well, the allegations in the complaint are my client paid these high fees. And if
But
it turns out...
how would they have altered their behavior if you knew what you think they should have been told?
Your Honor, I believe how they would have altered, they would have complained saying, you're charging me an amount that does not represent the true cost of insurance, which is what this clause was designed to do. This represents an amount that you've come up with where you've bundled in expenses that you shouldn't have.
But that just leads to the question, if you couldn't pay the premiums that existed, then no amount would have been financially within grasp.
It might not have been, but Your Honor, at the end of the day, if the property sold at foreclosure, do they not include that in the amount of the debt? I mean, I'm paying it. I might not pay cash for it, but I'm going to end up paying it by the equity in my property. So the idea that this doesn't matter, I mean, on a cash flow basis, I don't disagree.
I did not suggest that it did not matter. I was just asking you to specify what the reliance was on these facts.
I got a little excited.
Understand that it's a very troubling issue.
Well, and so you can look at it a cash flow basis, and you might be right on a cash flow basis, but if at the end of the day my client ends up from the equity in their house paying this, of course we've been damaged by it. How could we not have been damaged? And if the test is, you know, would we have dealt with a person who was going to have these back deals? The answer would be no, but to be honest with you, it seems sort of a little crazy to say, okay, to pose that question as if there's any answer other than, would you deal with someone who's back dealing on you? Well, the answer is no. And if that's the only issue, if that's the reliance that we needed, we did ask for leave to amend to correct any deficiency that the court saw. That's the sole issue, because he found it was material as to whether or not they had these back deals in place. So as to that issue, whether the omission meant something, he found yes. The only reason we're here is on the reliance. And I think we did allege that she paid it, and as a practical matter, whether she paid it out of ongoing cash flow or she pays it when the property is sold, that is a detriment. If I'm having to pay something that's inflated unnecessarily for a variety of different reasons that we've talked about, I am being hurt. That is not a fair practice. That is a deceptive practice when they don't tell me that the game is rigged. that I'm not getting a market rate. And when they come here and say, oh, Your Honors, all of this, we charge more because of this, those are all nice statements. But aren't we allowed to determine whether any of those statements are in fact true? That's what we're asking for. Thank you.
Thank you, sir. We'll come down, recounsel, and move into our last case.